A very good evening to you. Welcome to our company law class. Tonight, we are continuing with discussion of corporate finance, particularly shares. The last time, when we were ending, we had introduced the concept of the doctrine of capital maintenance. We explained the doctrine of capital maintenance, which goes back to the common law principle in the case of Trevor against Whitworth, to mean that a company must conserve its capital, must conserve its funds, which it has raised from shares that it had issued. We also explained it to mean that apart from the company maybe losing part of its capital funds as a result of maybe trading losses and things like that, under no circumstance should the company lose money which it has raised giving shares. In other words, we explain the rationale of capital maintenance to be that shares are issued by the company in order to raise money for the company. If that is so, then when shares have been issued and monies have come to the company in return for that, that money should be conserved, should be protected for financing activities of the company. And nobody should make a conscious effort or a conscious act to try and deplete or to try and squander monies raised by giving out shares. So that was the point that we made. And we noted that if we look at our Companies Act, the doctrine of capital maintenance has been given expression in the form of what we call prohibited transactions in shares. In other words, there are certain dealings which a company is prevented from indulging in with respect to its shares. And when these prohibitions or these restrictions are carefully scrutinized, you notice that what the lawmaker is doing is to try and achieve the same thing which the common law rule in Trevor and Whitworth sought to achieve, what commentators call the doctrine of capital maintenance. So therefore, we started looking at section 58. And section 58 has got the sectional heading, prohibited transactions. Of course, if you look at the heading of section 58, on the face of it, you will not be wrong if you came to the conclusion that what 58 is seeking to do is to outlaw, is to completely bar or prevent certain activities or certain transactions with respect to shares. Nevertheless, as we move on, you will come to appreciate that all that Section 58 is trying to do is that for certain listed activities in this provision, which relate to shares, those activities are forbidden unless a certain procedure has been provided for indulging in such activities, or unless certain permitted exceptions can be identified, which enable you to go around or to engage in what ordinarily might have been considered as doing one of the prohibited transactions in shares. So therefore, we started looking at section 58.1, and this is how we look at it. We look at the opening statement, what we call the chapeau, right? Section 58.1, except as provided in this act, a company shall not. So that is to say that the company is actually forbidden from doing what we are going to run through, the things which are adumbrated or listed in subsection 1 of section 58. But then I would like you to pay attention to what I call the opening words, the chapeau. Now, if you look at here, where I put like the, what do you call like the cursor, you will notice that, let me see if I'll get the ink. Okay, let me highlight it. So if you look at this one, where I've underlined, right? I've muted all your mic. If you want to speak, you have to raise up your hand so that I will release it. Good. So except as provided in this act, except as provided. What this simply means is that with respect to things which are going to be listed, which are going to be mentioned or adumbrated in section 58(1), a company, as a general rule, is prevented from engaging in, unless that company can bring itself within an exception anywhere in this legislation, anywhere in Act 992. If the company can actually identify a way out anywhere in this legislation, which permits the company to do that which is ordinarily forbidden or prohibited under section 58, then that will be tolerated. Otherwise, the company will be violating the capital maintenance doctrine. And I would like to draw your attention to something. If you look at the old legislation, that is the Repealed Companies Code 1963 at 179, the equivalent version of the provision in section 58 of the current Act 992 was section 56, right? Section 56 of Act 179. And I'd like us to compare the opening statement or the chapeau of the repealed legislation and also the current legislation. So I'm quoting from section 56(1) of the repealed Act 179. This is what it says, and I read: except as provided in this section, a company shall not. Good. Now I'd like you to pay attention to that. Except as provided in this section, a company shall not. Now, if you go to the current Act 992, section 58(1), which is the equivalent of the repealed section 56, it goes like this: except as provided in this act, a company shall not. Can anybody tell me the difference between the two which I have read? Section 58(1) now is saying that except as provided in this act, a company shall not. And then the repealed section 56 is saying that except as provided in this section, a company shall not. Anybody? Yes. This is section 56. You can raise up your hand and I'll allow you to speak. I'm just typing it out for you in case that will help you. Except as provided in this session. The company shall not. Yes, anybody? Yeah, so now let's just oppose the two. So what I've just put in the test box is the repealed at 179, and in that repealed at 179, we had section 56 one, which says except as provided in this session. Except as provided in this session. See, if you look at where I've highlighted. Now, if you come here, the current one, we have except as provided in this act. So the difference between these provisions, if you look at here, you are saying like this session. Oh, and it's not moving well, but this is important. Come back. Yeah, so you notice the main difference is here, the old one in this session, in the current one, say in this act. Now, those of you who are using, let's say, books by writers like Professor Bonzi Simpson, having a look at this current edition, but the old edition, which was based upon the at 179, he will have used the language, prohibited, total prohibition and partial prohibition, trying to make the point that some of the prohibitions in section 56 are total, absolute, meaning that there are no exceptions. And then some are also, partial. That is to say that exceptions are provided. Now, if that confusion, which was in the old law, has been corrected by the lawmaker, and that is why the lawmaker is careful to avoid except as provided in this session, to say that except as provided in this act, meaning that the things we are going to go through, which are supposed to be prohibited as a general rule, if we can find a way in any other area of this legislation, Act 992, which enables that to be done, then that will also be considered as an exception to the prohibition in section 58.1. So let us keep that in mind. Good. So having said that, let's look at the things which are prohibited in section 58. We said that a company shall not, A, alter the number of its shares or the amount of money remaining payable on those shares. So we've explained this before, the last time we explained it, that to say that, yes, as a general rule, when a company is registered, it is registered with a certain number of shares. We call that the authorized shares. Authorized, okay? The authorized shares simply refers to like the registered number of shares by which the company can give shares to those who are interested in subscribing shares. The company cannot give more shares than its authorized or the total number of its registered shares. So let's keep that in mind. And again, the amount of money remaining payable on shares which have been issued can also not be changed by the company. Because if you want to know the money which has come to the company as a result of shares, we look at the prices at which the shares were issued. We multiply by the number of shares issued at that price and so on. And then we get a sense of how much money has come to the company from there. And again, if you look at 51(1)(b), that the company shall not release a shareholder or former shareholder from a liability on the shares. We have noted from our earlier discussion of shares that giving now shares to a prospective shareholder, right? It is a contract which the company is entering into with the prospective shareholder. And for that matter, it may well be agreed that the prospective shareholder should pay only parts of the shares which are being issued, and the rest will be paid at a later date. So in that scenario, we have what we call an unpaid liability in respect of that shares. Now, section 58(1)(b) is saying that a company does not have the power to forgive any shareholder the debt that it owes the company as a result of shares issued to that shareholder which the shareholder has not finished paying. So let's keep that in mind. Then 58(1)(c), a company shall not provide financial assistance directly or indirectly for the subscription or purchase of the shares of the company or the shares of its shareholding. So again, this is a general rule because as 58(1), the Shapud opening statement says, except as provided in this act. And pretty soon, when we finish discussing section 58, you notice that in the subsequent sessions of provisions, we are going to witness a number of exceptions to some of these prohibitions. So let us keep that in mind. So as a general rule, a company is not supposed to give money to anybody to acquire its shares. Of course, shares are issued in order to raise money. So how can you give money to someone to acquire shares which are being issued to you? So let us keep that in mind. And not only that, it also applies to the company's its holding company. We have what they call the group of company phenomenon, okay? And we have what they call like a parent company and subsidiary companies. So a parent company will like the mother company, and then it has got shares in other related companies. And it may well happen that even it is the management of the parent company which actually even appoints or oversee management of the subsidiary company as it were. So this prohibition which the company faces with respect to not providing financial assistance to anybody to acquire its shares applies equally to its holding companies and its subsidiaries as well. Then 58(1)(d), a company shall not acquire by way of purchase or otherwise any of its issued shares or any shares of its holding company. So again, as a general rule, a company cannot buy shares of subsidiary company, or a company cannot buy back its own shares. If I say buy back, that is to say that the company has issued the shares to you, okay, maybe Kwame or Ya or Ajua or whoever, and you are the shareholder. The import of section 58(1)(d) is to say that the company cannot come to you, Ya or Ajua or Kwame, and says that we are buying the shares that we gave you. No, as a general rule, the company is prohibited from doing that. So let's keep that in mind. Now, all the things we have witnessed, right, in section 58(1)(d) essentially embodies the common law doctrine of capital maintenance doctrine, as we'll be discussing. Now, if we look at section 58(2), it makes a point that when it comes to shares, shares can be acquired or can be held in trust, okay, for a company. And when Section 58 1D says that the company should not acquire by way of purchase or otherwise any of its issued shares, it also applies to shares held by trustees on behalf of the company. So let's keep that in mind. And you are doing equity and succession, so I hope you understand what we mean by when we say someone is trustee, or if you don't understand, you can put up your hand and then I will explain. Notwithstanding the general rule that a company cannot acquire its own shares, Section 58, subsection 3 is saying that where it becomes necessary for a company to be converted from a company limited by shares to company limited by guarantee, then as we know under Section 9, if you remember last semester when we were discussing types of company, you are going to have company limited by guarantee, and we know that conceptually, a company limited by guarantee does not have shares, okay? All that we have is that members have made, if you like, a solemn undertaking regarding how much money they are prepared to contribute to meet the indebtedness or liability of the company should that become necessary. Therefore, where you have a company which is now company limited by shares, right? It wants to change its character, it wants to change its status to become a company limited by guarantee. It is the law that the shares which have been issued in respect of that company must actually be cancelled, must actually be returned to the company. And for that matter, the company may, for example, take back shares which it gives to shareholders and have the shares subsequently cancelled to pave way for changing the company from a company limited by shares to company limited by guarantee. So that is a special arrangement. And that is why Section 58.3 is saying that despite the prohibition in 51A that the company cannot acquire its shares, there's nothing wrong when it comes to the company acquiring its shares for purposes of being converted from company limited by shares, company limited by guarantee. So let's keep that in mind. And again, as we have known and appreciated by now, as far as company law is concerned, it is largely statutory, meaning that a good number of things are provided in a statutory law. And to secure compliance, sanctions are prescribed for default or for non-compliance. And for that matter, when it comes to capital maintenance doctrine, is not different. And that is why Section 58, subsection 4 is saying that where the things that we have discussed, right, is breach, is not observed, then, for example, with respect to the company, which is prohibited from altering the number of its shares or releasing a shareholder from liability that it has with respect to shares which has been issued to it, then Section 58.4 is telling us that any attempt to cancel or to alter the number of shares of the company is void. And again, any attempt to release a shareholder from debt or liability in respect of shares issued to it is also what? Is void. Not only void, the human beings, the officers who presided or who superintended over the company, when it actually sought to alter the number of its shares, sought to release shareholders from unpaid liability, are going to be made to pay a fine. And the fine they are going to pay is not the, what do you call it, the normal criminal fine. We call it the administrative penalty unit. Administrative penalty unit. We have explained the idea of the administrative penalty unit before, and the point we made is that it is a new introduction into our law, because previously, where someone defaulted and then the lawmaker wanted to impose sanctions, if it has to be a payment of money, that will be a fine. But if you look at the new law now, the Registrar General has been empowered, and it can inflict fines. And the fines that it inflicts, we call them administrative, and that is why we have the qualifier, administrative penalty units, which is different from like the usual court fine, because the court fine, you have to go to court and order, but this administrative penalty unit can actually be even be imposed by the registrar of companies. And the good news for the registrar of companies is that the new law has been configured in such a way that a significant percentage of the monies that it generates through administrative penalty unit, through various filing fees, will go to the registrar of companies as retention of its IGF for running its affairs. So if you have opportunity to be appointed the registrar of companies, please don't turn it down. It's a good post. Now, apart from the A and B, that is altering the number of shares, releasing somebody from the liability in respect of shares. Now, with respect to the other prohibition, that is the company providing financial assistance or the company acquiring or purchasing its own shares. Now, where those rules are not observed and they are breached, then 58 subsection 4B is telling us that any transaction, like where the company gave money to you to buy shares, that transaction is void. So the shares that you acquired will be ineffectual. So that is 1 point. And 2, the money of the company which was given to you to buy the company's own share will immediately be repayable, and you have to pay interest on top of it because you have robbed the company of money. So let's keep that in mind. And even the interest rate has been provided that the 91-day government treasury bill interest rate may be the applicable interest in respect of the money which the company gave you to acquire its shares, contrary to the capital maintenance doctrine. Or if you are not lucky and the matter is dragged to court, the court may even impose a higher interest or other consequences for you. Then, apart from that, even where the company has not taken steps to avoid the transaction, that is, where shares were issued as a result of money provided by the company to someone, maybe like the company discovers